City of Stevens Point Zoning Board of Appeals meeting, recorded February 20th, 2024.
It looks like it's about 6:07, and so we'll call the meeting to order and take the roll.
Schrader.
Here.
Klein.
Here.
Mark.
Here.
Doug.
Here.
4 present, we have a quorum.
Okay, our second item is to select a temporary chairperson for tonight's meeting, February 20th, 2024.
I would nominate Lynn Markham.
Does that need a second?
Second.
Okay. All in favor?
Aye.
Aye.
Opposed? All right. So first, we've got the minutes from the August 29th, 2022 meeting of the Zoning Board of Appeals. Does anyone have any changes on those minutes?
No.
If not, I would take a motion to approve.
So moved.
Second.
All in favor?
Aye.
Opposed? Okay. How about the November 9th, 2022 meeting? The minutes from that, any changes?
I had one on that one.
Yes.
It has Bob Weir present as a member.
No, he was not.
No.
Okay. Any other changes? Okay, a motion to approve?
So moved.
Okay. And a second?
Second.
Okay. And we've got one more set of minutes, March 7th, 2023 meeting minutes. Any changes to that set?
If none, so moved.
Okay. And a second?
Second.
Okay. All in favor?
Aye.
Aye.
Any opposed? Motion carried. Okay, so number 6, we have a request from Sue McCartney and Leif Olson for an area variance to subdivide the property located at 618 Portage Street, consistent with Chapter 23.05. Were you going to start, Adam, or?
I think I can actually start with some comments here real quick, just to kind of set the table. Obviously, you're probably not familiar with this process. The board generally is, but we still do these fairly rarely. So this is what's called a quasi-judicial process, which, unlike a, say, legislative process that you'd have before the city council, for instance, if they were just considering whether or not to adopt an ordinance change, they have essentially the freedom to just either do it or not based upon whatever happens to motivate them. Here we have, like I said, a quasi-judicial process. So it's not a courtroom per se, but there are parties to it. You filed a request for a variance. There's a legal standard that has to be applied. And in order to grant the variance, the board would have to find that that legal standard is met. So it's not really a matter of whether they just want to grant you something or not. It's a matter of what facts they believe have been established and then applying the relevant standard to those facts. Now, one thing I will mention that is a little different here than I think actually every request for a variance I've seen in the past is that the recommendation from the zoning administrator is to grant it. That I haven't really seen in the past, but it's one of those interesting things where the zoning administrator cannot just grant a variance on their own authority. The legal authority rests with this body to do that. Now, when you have a recommendation from the zoning administrator to grant it, certainly that is going to mean, presumably a leg up on it being granted. And in fact, I think it would not be out of order or anything like that for this body to base their findings upon the findings that are contained in the report. However, we certainly want to provide an opportunity for you to present your case here on the matter, an opportunity for Administrator Kuhn to present anything he wishes to, and for the board to ask questions based upon everything they're seeing here off the report and what they hear today. So So with all that, if any of you want to add anything, otherwise you can kind of take it away.
I would just add one piece, and that is anytime we decide on a variance, there are 3 standards that have to be met to grant a variance. And you probably saw it in Adam's report, but unnecessary hardship due to conditions unique to the property and no harm to the public interest. So those are the 3 tests that we need to apply.
Okay.
Well, I'm Sue McCartney. This is my husband, Leif. We live in Oregon, Wisconsin, and how we got here today is we have 2 adult daughters. Our oldest daughter, we've been visiting the Stevens Point area for over 15 years. She attended Wisconsin Lions Camp for several years and then was a counselor there. She attended university here, met her future husband here. Last summer, they moved here to Plover and had a baby. So we sold a rental property in our area with the hope of finding a 2-flat or duplex property here where we could use 1 flat as a second home for ourselves when visiting our granddaughter and daughter and her husband, and renting the other flat. So we finally found the 2-flat at 618 Portage Street. We closed December 5th, and then learned about this, noticed more carefully the split zoning and this big lot and these interesting garages. So on December 11th, we requested a meeting with Adam to find out what's going on with this property, what options are there for us to use the property perhaps more fully that would be aligning with the vision for the neighborhood and the comprehensive plan. And so he informed us that we could submit a zone variance appeal for a zoning variance to split the lot and perhaps build a house on that second lot and clean up some of the split zones.
So may I address some of the direct questions about the hardship? We really didn't know fully exactly what we were running into when we got into this, and that's why we went down to the village to discuss with them. We noticed the split zoning obviously happened. The lots had been combined in 2014 with the 2 different zonings. It appears if we had attempted to do anything, we'd have to be asking for a variance anyways. So we decided that it might be best to see if we can get it back to 2 lots and work through it that way. And that's, I guess, the harder to answer the hardship, I suppose, might be part of it, but we'd.
So we learned a lot by reading Adam's report and the challenges of the split zoning, which would, if we just repaired and expanded the current building, we would be non-conforming. We learned that their missing property was because of a fire, and so there might be some precedents to rebuild that. But what we'd like to do is, again, split the lots back to their original configuration and build a new structure that is conforming with setbacks. There's room for that. And repair the current house as a 2-flat as it currently is. So if we didn't do it, the large lot being split zoned would have various setbacks depending on what size of the lot you're on. And the structures, the garages are non-conforming now because of their square footage. I think that would be more in compliance if they were divided, is my understanding. So that's where we are with the challenges. And when we purchased it, we didn't really know why the lot was combined. We've since learned that later, but it seems to have made it more common. And so just by getting it back to its original configuration, be more in keeping with the other lots that are in that block. and the zoning could be cleaned up as well. That's what we'd like to do.
Okay. Do you want to take a turn, Adam?
Yeah, and if you could jump, actually a number of slides, it would be on slide 8. All right, so I'm going to start off with just a brief overview of the request, kind of getting to more of the technical reasons why the applicant is here today as it relates to the variance request. So as the applicant mentioned, the subject property is split zoned. I'll talk a little bit more later on as to what it means to be split zoned, how do you administer that, and the difficulties behind that. But essentially what the split zone designation means is that the west half of the subject property has a R4 multiple family 1 residential zoning classification, while the east half of the property has an R5 multiple family 2 residential zoning designation. The house that you see currently on the property on the east-hand side is a duplex. It looks like through historical records that it used to be utilized and built as a triplex, but at some point in the past, it lost its legal nonconforming status and was required to operate only as a duplex. The west half of the parcel, there used to be a triplex, same situation. It appears that prior to 2008, there was that loss of legal nonconforming status that resulted in the use at the time of the fire being that of a duplex. So as I mentioned, there was a fire that took place. That structure was raised in 2008 and has been vacant ever since. As I mentioned, the triplex was considered legal nonconforming. The one that did burn down because of mainly setback requirements as it relates to the building's proximity to the west lot line. At the time of the fire, there was about 2.6 feet of setback, whereas currently a minimum of 4 feet of side yard setback would be required off of that west lot line. Now the next slide. So typically, this is kind of getting into the legalese in our zoning code as relates to non-conforming structures. If a non-conforming structure is raised, a property owner can't rebuild that in the same footprint because it was considered non-conforming. If they want to rebuild a structure, they would have to meet current zoning code standards as it relates to setbacks, heights, etc. There is one exception as it relates to State Statute 6223(7)HC, and I'll apologize in advance. I did reference the wrong statute in my staff report. I mentioned the same verbiage as it relates to reconstruction of non-conforming structures that were lost because of a fire. That was under the villages section of state statutes, not under the cities. So apologize for that.
Really, really quick note. I did confirm this. The language in 61-351 that's referenced here and the language under the section of 62 or 62 you just mentioned are identical. So they read exactly the same.
And apologize, I can clearly assume you can't read the snippet of state statute shown on the far bottom of the screen, but essentially what this says is that if there was any non-conforming structure that was lost because of a fire, wind damage, and some other quote-unquote act of God type situations, if that fire happened after March 3rd of 2006, a property owner would be permitted to rebuild that structure like for like, even if it doesn't meet current zoning code requirements. And I'll preface by saying there is not a stipulation in state statutes that says a property owner has to rebuild that non-conforming structure within X number of years after the fire happened. If a fire happened on or after March 3rd or 2nd, hard to read here, 2006, they're permitted to rebuild that regardless of if it's 2 years after the fire, 10 years after the fire, 15 years after the fire. Actually, we could stay on here. So prior to 2014, the triplex and the two structures, the one that was raised and the one that's current, were on two separate parcels. In 2014, the two parcels were combined, and I'll talk a little bit more about that later on. So when the applicant approached me a few months ago talking about wanting to rebuild a structure, or wanting to rebuild a structure at the site where this raised building because of a fire, where that was located on the far southwest corner of the property, what I told the applicant is that, typically when folks would want to when folks would approach me wanting to build a second structure on the parcel, they would need a conditional use permit through our common council. One of the standards for reviewing a conditional use permit, and I included that in the staff report, is essentially saying that you meet the minimum performance standards for the underlying zoning district. And as it relates here, having two primary structures on this one parcel would require a minimum lot size of 16,000 square feet. And in this situation, they don't meet that 16,000 square feet. They're short approximately 556 square feet. That resulted in really the conversation, if we go on the next slide, Lynn, as it relates to the variance request. So the applicant is, as they alluded to earlier, is looking to reintroduce the lot configurations as was pre-2014, essentially splitting the subject property as is in half. And I roughly noted, using the red line, where that would be relative to the lot boundary as is. So since each proposed lot is required to have a minimum of 60 feet in lot width and a minimum lot size of 8,000 square feet, that is the reason for the variance request. So specifically, the ask would be a variance of 18 inches in lot width and a minimum of 278, and a variance of 278 square feet in lot size. Those would be the two requests of the applicant as part of this variance request. So going through on the next slide, 3 variance standards. Lynn mentioned that before. Unnecessary hardship is present. The hardship being claimed is due to unique physical limitations of the property, and that the variance will not harm the public interest. So on the next slide, I'm actually going to start from the bottom, the last one, and work my way up. So first, the variance will not harm the public interest, and some of the considerations that could be had into determining whether this variance should be granted is what's the impact of this lot split as it relates to potential light pollution, noise pollution, traffic generation, items like that. And I'll mention this a little bit later on, but essentially the purpose and intent statement behind our subdivision ordinance, chapter 20 of the city's revised municipal code, outlines in more detail about what are the specific items that are of interest for city staff in reviewing lot splits and more so regulating lot splits itself. So just a couple comments that I have bullet pointed here on the screen that I addressed in the report. So one, did have conversations with our Public Works Department about traffic generation along Portage Street should the proposed lot split be granted, since they're naturally going to be the experts. And in conversations with them, it didn't appear that there was any concern as it relates to a heavy increase in traffic being accrued as a result of the subject parcel being split into 2. As it relates to how the dynamic of the subject property was pre-2008 when there were 2 primary structures on the property, I took a look back at our archival records as it relates to potential code enforcement cases that were tied to either one of the 2 houses, and there were some cases as it relates to more property maintenance issues, tall grass, things like that, but nothing as it relates to, at least that we have in our records, lighting concerns, the physical condition of the structure at the time, etc., that would at least lend me to believe that there would be a negative impact on some of these surrounding neighbors. Last thing that I want to note is that the proposed parcel split would result in lots that have a larger lot width and lot size than lots that are located within the city block and within the vicinity. So most of the lots here, and it's hard to see on the image on the screen, but I'm looking at about the next 3 or so parcels to the east. They're all the same cookie cutter lots, 50 feet in width, 132 feet in depth. And it's my belief that since the proposed lot configuration would be bigger than that of the existing dynamic of the city block and of the general neighborhood in this area, that doesn't lend me pause for concern as it relates to some of those items that I mentioned: noise pollution, light, traffic generation, etc. Last thing, as it relates to this standard, so there were notification letters that I did send out to 200 property owners within 200 feet of the subject parcel. This is similar to what we do with any request going before our plan commission with some updated verbiage saying that, there's not a public hearing held, but if you want to provide comment as it relates to your thoughts, you're more than welcome to address that to me so I can take a look and make that determination as relates to the standard. As of right now, I received one comment, and this was about an hour and a half ago. It was a pretty lengthy email, so if you do, as a board, want to look at that, I can defer to Attorney Beveridge, and if so, I can pull that email up, or I can pull it up on the computer when you deliberate. Next slide, if we could talk about the unique property limitations. So first off, it was mentioned in the application that one of the unique property limitations relates to non-conforming accessory structures. And what I mean by non-conforming accessory structures is that for any parcel here in the city, you're afforded, that property owner is afforded an unlimited number of accessory buildings. These would be any detached accessory buildings. These would be detached garages, carports, sheds, pergolas, etc. You're allowed an unlimited number so long as that cumulative size does not exceed 900 square feet. So it was referenced in the application that was one of the unique property limitations, that the subject property had well more than 900 square feet of accessory structures. There's two parcels that were located, or two accessory structures located on the parcel. One, 560 square feet, one, 1,104 square feet. Short answer is that by itself, I don't believe is a unique property limitation. There are a plethora of parcels here in the city that exceed 900 square feet. And just looking at the city block, I have the three parcels noted as exceeding that 900 square foot rule, the subject parcel, and then the two others on the far corners of the screen. If you go on the next slide, I did want to talk, though, about two things. First being the loss of a non-conforming structure due to a fire. We're privileged, given our city fire department and our joint response through neighboring municipalities, that it's pretty rare for a non-conforming structure to be raised to have a total loss because of a fire. And it's even more rare for property owners wishing to rebuild that structure after the fact. In my 4 years here with the city, there's been one example where a property owner wished to pursue that. It was a triplex that one of the units burned down. It was a triplex where it's not conforming with respect to not getting a conditional use permit and with respect to lot size. Because of this provision in state stats that I alluded to earlier, they were able to do the renovation work needed for that third unit and reoccupy that space. So that in and of itself, because of the uniqueness of the amount of properties where that exists here in the city, I think that's a nugget in this case that could help assist in proving why that hardship is being claimed and why the fire occurring contributes to that claimed hardship. And the second thing that I wanted to mention is just the split zone nature. And I wanted to talk a little bit more about split zoning, what that is, because it's not generally applied here elsewhere in the city. So first off, a split zone parcel essentially means that there's two zoning districts that fall within the same parcel. Some other communities, instead of using the term split zone, they call it dual zoned. This does not mean, this does not equate to properties that have a base zoning designation and an overlay zoning designation. So the image on the left-hand side of the screen, I have basically the city's north side, Division Street. That's located, those properties that you see shaded in that light gray color, they have a base zoning of B4 commercial, but they are located within the BTID 5 overlay district. Those properties are not considered a split zone property because of that dual zone and overlay zone designation. What I mean by a split zone designation, and I just took a random example, this isn't a specific property in mind for the image on the right-hand side of the screen. Took a cookie cutter lot, 50 foot by 132 foot, and gave a split zone of the front half being zoned R2 single family and the back half being zoned R5 multifamily 2 residential. Some communities allow for split zone parcels to be created. Stevens Point is not one of them. For communities who do allow that, they pretty explicitly state in their zoning ordinance how you administer split zone parcels, because there are some tricky components as to how you administer that. If you have two zoning districts with different setbacks, I gave the R2 and the R5 district as an example. The R2 district for this parcel would have a rear yard setback of 26 and a half feet. The R5 district would have a rear yard setback of 20 feet. Which setback do you use based off of the building configuration on the parcel? And also use as well, which is not as much relevant in this case, but if you have a use that's permitted in one district and not permitted in another, what do you do in a situation like that? As it relates to 2014, why these two parcels were combined, creating the split zone parcels, frankly, I can't tell you why. It shouldn't have been approved back in 2014. That and creating more nonconformity with respect to that accessory structure, the 900 square foot rule. I don't know why it was obtained, why those two parcels were combined, but needless to say, that's kind of the issue where we're at right now, is because of the split zone designation, it contributes to this more difficulty, in my opinion, of building a structure on this west half of the parcel. And the last thing, the last item in this, honestly, in my opinion, is going to be the most critical review standard for the board to determine is basically, is a necessary hardship present? And I'm going to actually pull up state stats right now, and I'm going to read this to you verbatim. So, quote, a property owner bears the burden of proving an unnecessary hardship for an area variance by demonstrating that strict compliance with the zoning ordinance would unreasonably prevent the property owner from using the property owner's property for a permitted purpose or would render conformity with the zoning ordinance unnecessarily burdensome. So for the first half, would it unreasonably prevent the property owner from using the property owner's property for a permitted purpose? The subject parcel currently has a 2-unit residence on the parcel. That is a permitted use within both the R4 and R5 zoning district. So for that first half of this provision, I believe would not be met because it's still being used as a duplex, and even if the variance is not granted, it could still continue to be used as a duplex, which would be permitted within both of these zoning designations. The second half is, quote, would the area variance, would it render conformity with the zoning ordinance unnecessarily burdensome? And as I mentioned at the beginning with state stats, the burden of proof is on the property owner for proving if an unnecessary hardship exists. And as I mentioned in the staff report, it's a subjective analysis. There's a spectrum as to how one determines if a specific regulation is deemed unnecessarily burdensome or not. Of the hundreds of regulations that make up our zoning ordinance, I'll be honest, there's some of those regulations that I think are more burdensome than other, but I understand that each one of you four are going to fall on a different end of the spectrum or different point in the spectrum as to where you consider a specific piece of regulation to be unnecessarily burdensome or not. So one way to assist you folks in determining if it is unnecessarily burdensome is really to understand the purpose and intent behind why we have the zoning ordinance or the regulation that the applicant is requesting a variance from. And that being, why do we regulate lot divisions here in the city? So I pulled up, as I alluded to earlier, this is a full snippet from our subdivision ordinance, the purpose and intent statement of our subdivision ordinance, focusing on some of those key points that I mentioned before, the noise, light, traffic generation, impact on community facilities like parks, schools, items like that. I think, in my opinion, the difficulty with this unnecessarily burdensome case, it kind of stems back to the nature of the fire that happened, and the fact of the matter is that if a fire didn't happen, yes, we may be having a conversation about this variance, but it'd be a pretty clear case that a variance could and should not be granted. Also, I think that if it wasn't for these lots being combined in 2014, the applicant could pull a building permit through our department on this day and start construction. Why the two parcels were combined, I don't know. I don't put that onus on the property owner to say, because of a parcel combination that shouldn't have happened, because of that, they shouldn't be allowed to utilize that provision of state stats that permits that reconstruction of a non-conforming structure. And as I mentioned earlier with the impact on the surrounding neighborhood, really looking at the purpose and intent. It's my belief that should the board determine that a variance should be granted, I don't necessarily believe that it will be askew with really why the purpose and intent statement that's shown on the screen. So with that, like I said, ultimately the decision is up to you, especially for this unnecessarily burdensome test, and happy to take any questions.
I have some thoughts I want to share in this that I think it would probably actually make sense to share in open session. Now, I'll leave that up to the board if you want to hear these from me in open session or in closed session. Any thoughts on that particular ask? Go ahead.
I'm fine with
Go
open
ahead.
session.
All right. So, as I was reading through this, I struggled just with trying to put these different pieces of information into their right place through the normal lens that you view these types of questions through. Because you have this, not only, like, the unique thing here arises out of the statutes. It arises out of that you have a right to rebuild a non-conforming structure. And that, I was like, oh, maybe I'll find some guidance within the case law. I cannot find a single case in the state of Wisconsin where, much less the court actually breaks down like what this really means, I couldn't find a single case where that statute's even referenced. Like, in all the case law in the state of Wisconsin, that string of characters does not appear, and nor does the one from the villages appear, the 61.
I
So it's a
believe
ghost.
that's in part because it's quite new.
Yeah, well, yeah, it's reasonably new, but although I'm a little surprised just because you'd think that this would happen somewhat frequently,
Sure.
and that it could lead to some weird questions. But so I was a little taken aback by that. But I think the hardship question is a tricky one. But literally, as I was sitting here today, it occurred to me, which is, as it sits right now, they could pull a building permit and rebuild that structure on this lot. They'd have two principal structures on the same lot. That's weird. Why is that weird? Well, A, our zoning code doesn't allow it, but this statute would supersede that right now. But also, one of the things you might do with a house someday, if you own it, is put it on the market and sell it. Well, if you got two houses in the same lot, it makes it awfully hard to sell one and not the other. And it makes it awfully hard to sell either of them because who's going to want to buy one lot with two houses on it? You also have the question of the accessory structures. You've got two accessory structures here. One is 1,104 square feet and one is 560 square feet. Currently, if you build a second home there, well, you might want to have a second usable garage. And your hands are completely tied. You could tear down the 1,104 square foot one and build a new one of a whopping 340 square feet, which is about big enough to put, a single car in, as long as you can shimmy your way out the side without opening the door very far. Whereas if you split the lot, you can build a 900 square foot garage on the new lot, tear down the other one and rebuild it to 900 square feet if you'd like something newer. But essentially, if you build the house on the existing lot, you've just incredibly curtailed your ability to ever sell either of them in the future in a way that I think would quite strongly create an undue hardship. But also, like when you talk about the factor of a physical characteristic of the lot leading to that, well, we can talk about geometry. Is there anything shockingly unique about a roughly square lot of this many square feet and this type of dimension? Well, maybe not. It is extremely close with regards to, 18 inches short on the width once it's split, a couple hundred square feet on the square footage. So obviously that is close, but I think there's another way to look at the unique quote-unquote physical characteristic of the lot. If you'd have been standing there in the sidewalk the night that that house burned down, there'd be nothing not physical about that event. I think to say that a destruction by, fire of a existing structure and then this hulk of a burned out thing that's unrebuildable, I think that does constitute a unique property condition. Now, it's a little harder for us to sort of conceptualize that because it's long gone and cleaned up and it just looks like some grass there. But at a time in the past, it was very physical. So that's kind of how my thoughts have changed on it as I've just sat here, and it's not like I was hesitant to find any of those. I was just having a hard time conceptualizing them. So now, obviously, the board's not tied to my thoughts on this by any means, but I did feel I wanted to share that with everyone rather than us going into closed session and me saying all those things. So.
Adam, quick question. Is it possible to find the records of who recommended combining two lots with different, it's puzzling to me, like.
Yeah, I looked, so back in 2014, I don't believe the County Register of Deeds office had a request to combine parcel form. That's an option that we have today where if somebody wanted to combine two parcels, yes, technically you could do it by way of a CSM, but why spend thousands of dollars? There is no record on the property file through the county GIS noting that there was a CSM filed in 2014 noting that. So that the reference why I knew it was 2014 is because that's through our assessor records, but who signed off on it or kind of the details behind why that became combined, I personally can't tell you. I don't know why. I wish I did, because that would provide a lot of clarity.
I have a question. I think you cleared it up a little bit when you cited the 61 chapter, the one you corrected.
Correct.
When and maybe I'm wrong, but I looked at the heading, it was for wetlands.
So
is the 62 wetlands too, or is that not wetlands?
It's not.
It's not wetlands. Okay.
Yeah. So
I had the question because it was wetlands. I thought that this isn't okay.
Yeah.
That answers it.
It would be what's the provision? So 6223 sub 7 sub HC. And it's under the city planning section, and the title is restoration or replacement of certain non-conforming structures.
Okay.
I also felt like that was a key point.
Yeah.
Yeah.
Yeah, when I read that, it struck me as, because every now and then you find a provision in the statutes where standing alone, you go, why is this contained in a section that seems to more broadly be about a somewhat different bit of subject matter? But yeah, once I was able to find the part in 62, like the actual text is the same. It's just in 62, it's a standalone provision as opposed to being contained under a wetlands heading, which, yeah, a little bit weird.
Yeah, okay. And I did check back Plan Commission minutes in 14, the whole year. I couldn't find anything.
Yeah.
Good for you.
There was a record in, it was mid-2000s. I believe it was pre-fire, where the Plan Commission and Council authorized the west half of the parcel to be rezoned from R5 to R4. Originally, there was a request for that whole row of houses on the north side of Portage to be rezoned from R5 to R4. Whatever reason, during the Plan Commission meeting, they said, no, we're not going to rezone all half dozen or so. We're going to rezone just this one.
Yeah.
Why? Couldn't tell you.
At that time, they were looking at rezoning a lot of that around the university and certain areas to student housing and stuff. That's what I remember.
Okay.
But the mayor at the time wanted to do that, but it didn't go very far.
Are we going to go into closed session, or do we just?
Because
we'll call.
Okay. So is there anything else from the applicants or Adam? Okay. Okay, so item 7 is moving into closed session pursuant to Wisconsin Stats 19.851A, deliberation concerning a case. Someone want to make a motion?
I'd make a motion, we go into closed session.
Okay. I'll make a comment that I don't agree that a variance decision is a case. Case is defined in Chapter 19 under 1985 as an adversarial proceeding. It says it does not connote the mere application for and granting of a permit. I went back to that Hodge case that case comes from, and it says, case in legal terminology is a proceeding by which one party seeks to obtain relief against the other named in the suit. So for that reason, I don't think it's a case. I don't believe we should go into closed session, but we have a motion and a second. So, all in favor?
Aye.
All right.
Okay, all against? That'd be me. But now we move into closed session. Go. Okay. So do we have a motion?
Motion to approve the variance because strict compliance of the ordinance is unnecessarily burdensome.
Do we need a vote to return into open session, or did you do that?
We
We did that in the
We did.
closed session.
Yes.
I'll second that.
Any discussion? Okay, I would add to that part was the unnecessary hardship part. We also agreed with the staff report that the hardship is due to unique conditions of the property, given the loss of the structure due to a fire, and that the variance will not harm the public interest. We also noted that Wisconsin statute 6223(7)HC would allow rebuilding of a non-conforming structure regardless. So, okay. All in favor?
Aye.
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 Any opposed? I think we all said aye. Okay. I would also just put the recommendation in there that the Plan Commission, when they're revising the zoning ordinance, consider reducing the residential minimum lot sizes for these districts.
For the R4 and R5?
Yes. Okay. Motion to adjourn?
Motion to adjourn.
Second? Okay. All in favor?
Aye.
Okay.
A video of this meeting is available for viewing on the city's website, stevenspoint.com/videos.